All right, and the court usually does not do this, but because there were notebooks that were presented to the court did review those. So we're going to go on the record. Court is going to call 2020 CR 9647, State of Texas versus Jonathan Keith Yost. Could I have parties announced for the record for the state?
Richard Getta for the state.
Defense?
Cornelius Cox.
Are you Mr. Yost? All right. So in this case, the court was presented with a lot of exhibits, and those exhibits include these two notebooks. The court did review those once the court was made aware from both parties that this was going to be a plea that was going to be entered. Any objections to the court having reviewed the two notebooks, one being black, one being white? State?
None from the state.
Defense?
Oh, yeah.
Mr. Yost? Okay. All right, counsel, have you received all the discovery and did you review it with your client?
Yes, sir.
Court will find that the state is in compliance with discovery. Mr. Yost, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
Yes, sir.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
So you're proceeding on counts 1, 2, and 2?
Yes, Your Honor.
Okay, thank you. All right, Mr. Yost, I'm going to show you what's entitled Court's Admonishments and Defendants' Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, sir.
Did you understand in each count, you're charged with the offense of theft over $300,000? Well, theft over $300,000 and money laundering over $300,000. Did you understand?
Yes, sir.
All right, each of those counts are first-degree felonies. The range of punishment is 5 to 99 years or life in prison with a possible fine up to $10,000. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Yost, has anyone threatened you, coerced you, or placed you in fear to get you to end this plea? Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at a cap of 20 years in the prison. The state makes no recommendation for a fine. There are no applications. There's to be restitution to Dr. Ashok, A-S-H-O-K, thought-provoking, T-H-O-L-P-A-D-Y, in the amount of $400,000, and there's to be no contact. Did you understand that to be the plea?
Yes.
Defense?
Sure.
State?
Yes, Your Honor.
I'm showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, sir.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
Clear.
Then count 1 in the indictment, how do you plead? Guilty, not guilty, or no contest? Count 2, how do you plead? Guilty, not guilty, or no contest? State, any evidence to support the defendant's plea?
Yes, the state offers State's Exhibit 1 and all attachments.
No objection.
All right, I'm showing you what's entitled Wavering Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty in count 1 and guilty in count 2. This will come back for PSI on August 24th. Mr. Yost, at that time, the court will make a decision on your sentencing based upon the PSI report I received back and any other evidence that's presented to me. Do you understand? Oh, it's a pre-sentence investigation report. Basically what it is, it will show me what your criminal history is. It may have statements in it from the complainant, statements maybe from yourself, and any other information about you. And then I'll base my decision upon that and also any other evidence that's presented to me. Do you understand?
Yes.
All right. And Mr. Yost, just so you know, I will receive the PSI report, but I don't review the PSI report before both the state and defense have had a chance to review it and let me know if they have any objections to it. So I'll review it after that point. All right.
If I may,
Yes.
with the, with my client's bond status.
Mhm.
His bond was set very high. And the problem is that it's not that he's trying to buy out. The issue is that because of the high bond,
Mhm.
he's locked down
Mhm.
23 hours.
Okay.
And we're asking the court if the court, even if the court remanded him without, then I think he will go back to general population. We just want him in general population, so he's not locked down 23 hours.
Well, that can be accomplished by one or two ways. One, if you want the court to remand him without bond, I'll remand him without bond. If both of you all would like for me to contact the sheriff's department and say, what is the reason for his lockdown? Is his lockdown because of the high bond or something else? Then the court can look into that.
Okay, that'll be fine. If we can get him just in regular population, that's always
Okay.
GP.
All right. So if both parties are okay with the court asking the sheriff's department why he's in lockdown,
I'm okay with that, Your Honor.
okay. All right, so I'll talk to them today. I'll put that on my to-do list.
Thank you.
Okay,
Thank you, Your Honor.
you're welcome.